Chick-fil-A, back in the news again. So a Chick-fil-A worker endured racist abuse at the Idaho location. This is like extreme racial abuse. Put up the picture full mass. According to Atlanta Black Star, Lauren Mosteller on the left, franchise operator of the Ammon, Idaho Chick-fil-A restaurant, is being sued by a former black employee who claims managers, including Jessica Lanehart on the right, failed to intervene when he reported racial harassment by coworkers. The federal employment discrimination lawsuit claimed his coworkers subjected him to relentless racial harassment, including calling him an ape, calling him the N-word, and also comparing him to a slave. According to his complaint obtained by Atlanta Black Star, shortly after Thomas Wade started working as a cook at the Chick-fil-A franchise in Ammon, this is a suburb of Idaho Falls, in December 2022, he applied for the company's leadership development program, but was passed over for a white male employee. Mr. Wade was assigned to the, quote, back of house crew at the restaurant where multiple members of the Ibarra family worked, including Eric Ibarra, his supervisor. In March 2023, Mr. Wade says he intervened when Isaiah Ibarra, Eric's son, and another employee were antagonizing a third coworker. Quote, "Shut up, ape, before I put you in a cage," end quote, Isaiah Ibarra allegedly said to Mr. Wade. When Mr. Wade said he would report the conduct to management, Isaiah allegedly called him a, quote, monkey-looking ass, end quote, and warned him that, quote, "my parents own this store," end quote. Mr. Wade complained about the racial slurs and intimidation to Eric Ibarra, who, quote, did nothing according to the lawsuit. Nor did back of house director Kayla Barnes or general manager Jessica Lanehart, who Mr. Wade says apologized but did not discipline either Isaiah Ibarra for his racist comments or his father for failing to discipline his son and failing to bring the matter to the attention of management. Mr. Wade took 2 days off to give himself some space, according to the suit. And when he returned to work, he claimed several members of the Ibarra family chimed in with more racist comments, which only worsened over the next several months, 7 months to be exact. Isaiah Ibarra, his brother Noel Ibarra, and other co-workers called Mr. Wade ape, monkey, N-word, and antique farming equipment in reference to slavery, the complaint says. They also told him they would put him in a cage. Quote, "Of course he works at Chick-fil-A. Quote, "Of course he works at Chick-fil-A. He's black, so he loves chicken," end quote. That's what one Ibarra brother allegedly said to the other in Mr. Wade's presence. They're talking to each other, saying these comments. On another occasion, Mr. Wade says he walked in on Noah Ibarra whipping co-worker Lime Hardy with a towel, when the latter said, quote, "Please, master, I'll work harder," and quote, "Yes, master," end quote. Hardy then said Mr. Wade, quote, "would know about getting whipped since he is black," end quote, the lawsuit states. Between the month of March and October 2023, Mr. Wade says he made between 25 and 30 reports to either Ms. Lanehart or Barnes about the racist comments coworkers made to him or made in his presence. Okay? Now, what do you have so far? You have a family affair. That's what you have. Okay? You got a family affair. Everybody is participating in this extreme behavior, and it seems as if those who are put in positions of supervision or management, they are either A, co-signing on it, or B, unwilling to do a damn thing about it. Now, they may feel as if they are powerless because the family is in charge of said restaurant, but you see, here's the thing. Regardless of what you may think inside of your head, you are working for a corporation that allows for the public to access it, which means you must abide by public accommodation rules. And if you do not abide by public accommodation rules, we're not even getting into the discrimination dynamic yet. If you don't abide by the simple public accommodation rules, which means fair treatment for everybody in said establishment, that includes workers and customers, you are in fact responsible. That included one day, June 2023, when Sativa Cortez, one of Eric Ibarra's daughters, taunted him by saying, quote, "Look like a monkey, act like a monkey," end quote. While he was waiting outside his supervisor's office for a meeting to discuss the ongoing harassment, Mr. Wade says he told Ms. Lionheart and Barnes about the racist slurs coming from the Ibarra siblings, including the latest from Cortez, and pointed out that, quote, management in action emboldened the entire Ibarra family to continue harassing him. Lionheart said she would speak with them, quote, but nothing changed, the lawsuit states. July 24th, 2023, Noah Ibarra and co-worker Joshua Ramirez called Mr. Wade over to see what they had written on the freezer, the complaint says. On it, Mr. Wade says he read Danny G. German. He didn't get it at the time, but later Ramirez explained that separating "da" and "man" from the middle letters reveals an obvious slur, which Mr. Wade reported to Barnes that same night. Barnes appeared annoyed and told Mr. Wade that if he wanted to be a shift leader, quote, he needed to get along with the Ibarra family, quote, because several of them were already in leadership positions and she shouldn't fire them, the complaint alleges. Now, Mr. Wade claims he also told Barnes that Noah Ibarra consistently called him Blackie, N-word, and monkey. But he never heard from her or Lionheart about any action taken about it. Other employee misconduct also went unpunished, Mr. Wade alleges. Late July 2023, Noah Ibarra was suspended for sexually harassing a coworker, and after returning, he, quote, continued to act out and was fired as a result, the lawsuit says. A month later, he was rehired. That is called negligent retention and then negligent rehire. In August of 2023, Mr. Wade reported to his shift leads, Eric Ibarra and his wife, Veronica Ibarra, that their daughter, Sativa, had just called him back of house monkey. They allegedly told Mr. Wade they could do nothing because Sativa was a supervisor. That same month, Lionheart allegedly asked Mr. Wade, quote, why he would want to work in a place where he was being harassed all the time, end quote. On October 14th, 2023, Mr. Wade says he complained again to Barnes about the racist slurs and harassment and told her she needed to do something about it. Instead of addressing the misconduct, Barnes told Mr. Wade, quote, she wasn't scared of him, he claims. 2 days later, Barnes and Lionheart fired Mr. Wade. May 2024, Mr. Wade duly filed, a charge of discrimination with the Idaho Human Rights Commission and the Equal Opportunity Employment Commission, both of which found merit in his claims that illegal discrimination and retaliation had occurred according to the lawsuit. Now I'm going to explain why that part is important. Many times when you have discrimination claims from a corporation, you work at, say, a corporation and you believe you've been discriminated against, typically an attorney will only take that case if you have been cleared to sue by that state or federal agency dealing with discrimination. And the reason is because they do somewhat of a vetting process to make sure that statutorily, based on state and federal law, you meet the prerequisite standards to file said lawsuit. So he meets the standards. Now, February 2025, the EEOC issued a notice of right to sue. And on March 13th, Mr. Wade filed his lawsuit in the United States District Court in Ohio against Lauren Mostella Incorporated, who is the Chick-fil-A franchise operator. The franchisee, Lauren Mostella Inc., doing business as Chick-fil-A. It is a Georgia-based company owned by Lauren Mostella, who is also the restaurant operator in Ammon. On Tuesday, a Chick-fil-A company spokesperson told The Independent, which first reported on the lawsuit, quote, "This matter involves a franchisee, not Chick-fil-A Incorporated." I got something to say about that in just a moment. Franchisees are independent operators responsible for all employment decisions in their restaurants. Chick-fil-A Inc. is not involved or aware of their employment matters. Shame on you, Chick-fil-A. Damn shame on you. The reason why I'm calling you out is because that restaurant is a licensee, okay? That's a licensed restaurant. You give it the license to utilize your brand, your logo, your slogans, your meal prep, your vendors, etc. They had to apply for said license, and in order to get those license or that license, they had to agree to do certain things a certain way. As a matter of fact, if that restaurant was open on Sunday, you would snatch his damn license in a minute, because that's one of the rules for using the Chick-fil-A brand. You also have a morals clause. I know this because many years ago, I looked into purchasing one of your damn restaurants before I understood what kind of entity you were running. Your morals clause, that's enough right there. If an owner is accused and convicted of theft, if an owner is accused and convicted of any kind of crime, you all have the right to snatch away that license immediately. You utilize it as leverage in order to make sure that these franchisees are in fact compliant with the standard of Chick-fil-A. This response is ridiculous. As if somebody can boldly proclaim the brand of Chick-fil-A, but there is absolutely nothing you can do to enforce the standard of Chick-fil-A. That's what you would like people to believe. In their answer, the complaint filed May 7th, Mostella Inc. denied all of Wade's claims of discrimination and misconduct by its employees, calling them, quote, frivolous, unreasonable, or groundless. The company asserted that any injury or damage suffered by Mr. Wade was, quote, caused and contributed to by the negligence and fault of plaintiff or a third party, and that his allegations of isolated, sporadic conduct are insufficient to establish a hostile work environment. That is an interesting way to put it. That's actually not true based on the law. It is the inaction of management. You all have basically admitted that at least sporadic incidents happened. By you saying this, you also admit, at least in a roundabout way, that you were aware of sporadic incidents, but you said this attributed to either his actions or the actions of a third party. Your lawyer is dumb as hell if they help you craft this, because it's not about the actions that have happened to him. It is about the inaction of management to do something about it. Oh, they got you. They got you. you all were aware and did nothing? Well, that's the part that matters in court, not these other parts that you're proclaiming. Mr. Wade was terminated, not in retaliation, according to them, for reporting racial harassment, Mostella argued, but due to his, quote, failure to satisfactorily perform his job responsibility and otherwise conduct himself in accordance with company policies and standards, quote, the franchisee of the Chick-fil-A at issue is confident that the allegations in this lawsuit are entirely unfounded. Kelly Rooksby, an attorney representing Mostella, said in an email statement to Atlanta Black Star, quote, the case remains pending and we are fully prepared to demonstrate that there was no unlawful conduct. We trust that a jury will reach the same conclusion. This is going to be interesting. They're talking big and bad now. We shall see how it pans out in the very near future. Sharon, this is an interesting story. And I will tell you this, typically from the EEOC perspective, it's not easy to get these kinds of approvals or right to sue letters. And that's why attorneys, they jump on them right away because they know the vetting process has already been done. The young man obviously has more than just some he said, or he said, she said. He has some actual documentation and proof to back up his claims. What say you?
Well, I think you're so smart and appropriate to jump on Chick-fil-A corporate instead of the Dippy family franchisees and their, I don't know what's going on with the lawyer there. Perhaps they used chat and didn't double check it like you're supposed to. Listen, the Chick-fil-A normally has a duty that they can pull the franchise agreement, as you alluded to, Doc, and they usually have a duty to give the franchisee some time to correct the behavior, but not always if the conduct is most egregious, like in this case. They can do it immediately. They can get change here. I just think it's ridiculous. This is the time of year where I am usually overcome by my addiction to a temporary menu item, the peach milkshake. It would be my pleasure to boycott it this year. I don't need it anyway. Okay, Chick-fil-A can do better and they better do better.
That's right. You know, I think some of these corporations are overestimating the Trump effect.
What a dumb letter.
To
what a dumb response.
To judicial review. So we shall see.
Doc.
All right.